Are we on?
Yes.
Yes, we hear you, Catherine.
Great. Good afternoon. Welcome to everyone who's joining us. My name is Catherine Batista. I'm an employment and labor attorney with Offit Kerman, and I'm presenting with my colleague Ari Karen, who is also a principal at Offit Kerman and also the founder and CEO of Strategic Compliance Partners. So today we're going to walk you through the current status of sexual harassment and prevention techniques, compliance with new legislation, and sort of explain to you what the best general practices are for prevention and compliance, and then we'll go into some specifics of those. So these headlines should look all too familiar. This is sort of what we've been inundated with in the last year or so since Harvey Weinstein. And unless you've been living under a rock, you certainly have seen the detrimental effects that some of these allegations have caused to certainly the people accused and also the businesses that they're a part of. So we know why sexual harassment is a problem from a moral or an ethical standpoint, but we also wanted to explain to you some of the other, perhaps more nuanced reasons why it's so important to make sure that you are compliant with the law and that you have preventative techniques in place. Obviously, the PR angle on this is huge. These types of allegations surfacing not only can cause problems for a company, but also what we've seen is that they open the door to a lot more allegations surfacing that have, been sort of not under wraps or not known about for a long time, and that really adds to the potential PR issue that this can create for companies.
One other thing to add into this is also don't underscore the possibility of these being used offensively. And what I mean by that is take a scenario or as a good defense, and what I mean by that is you have a scenario where, let's say, you have these allegations that start to gather some steam, and now you have an employee who left, who violated a non-compete agreement, right? And you want to go after them. And now guess what they raised? Oh, well, this happened to me too. Pardon the pun a little bit here, right? But people can start using them as defenses. The best defense is good offense to stop you from enforcing your rights. And that's particularly in the lending community where we've seen people do this type of thing. And I think sexual harassment is going to be just another, you have a married CEO and somebody claims this type of thing. You can see where you could use this as something to deter you from enforcing your contractual rights or other legal rights against an employee.
And then the other piece of that is sort of looking at, we're looking at it from a management, from a company perspective. And then there's also the viewpoint of the effect that it has on the workforce. Certainly, it causes disruption to the business. It has the potential to lower productivity. That, of course, in turn has an effect on the overall profitability of the company. If you have an ongoing sexual harassment investigation or allegations hanging over people's heads, it tends to cause a lot of rumors and a lot of overall disruption to the overall course of business. And that, in turn, can affect your recruiting efforts. So certainly, in such a competitive industry and what, how competitive it is right now and what candidates are looking for, you want the best candidates. You don't want something like this that can easily be prevented to dissuade really good applicants from coming to your company just because certain procedures weren't put into place or certain remedial measures weren't taken. We wanted to display for you just some of the recent judgments and awards that have been issued with respect to sexual harassment claims. at the risk of this being a scare tactic, that's not the intention. It's simply to show the gravity of where these claims can go. Oftentimes we think of big money judgments not necessarily being associated with employment claims, but as you can see, with sexual harassment claims, there is the possibility, even when you have just a single plaintiff, to get into those larger judgments. You can see here, we have this 2012 award. This was actually the biggest single plaintiff employment award until just recently, and that was just a claim by a physician's assistant who was working with a group of surgeons who claimed long-term sexual harassment. Specifically, she claimed that it went on a lot in the operating room. So the court weighed heavily the fact that it was an area where the plaintiff couldn't leave. And then some of these examples are ones that we're all aware of. Certainly, Gretchen Carlson is a higher paid executive, so it's not terribly surprising that. And there was a lot of publicity surrounding her claim, so it's not terribly surprising that resulted in a larger settlement. But it runs the whole gamut. We have both higher profile cases here as well as cases that dealt with more run-of-the-mill employment relationships. You have a furniture chain here, you have standard retail. So there's the potential for these types of judgments everywhere.
Yeah, and a big part of these cases, just don't forget, is emotional distress. They generally are recoverable in sexual harassment claims. So if somebody can show they suffered severe emotional distress with physical, implications to them, whether it's couldn't sleep at night, whatever it might be, that can certainly lead to larger judgments, and it's something the plaintiff's bar will utilize.
So now that we've given you a little bit of background and stressed the importance, we want to make clear what we're really talking about and what the law views as sexual harassment. In its most basic form, it's unwelcome conduct that is based on the victim's sex. Now, the common misconception is that it has to actually be sexual in nature, which isn't true. It can be both sexual in nature, or it can be hostility exhibited towards the victim that is related or based on their sex. So that can be derogatory terms that have no sexual innuendo.
Yeah, one of my favorite cases is that I've known about, and it's actually a kind of a pretty famous case you may know of, but Catherine. But it just shows you how broadly it can be utilized. There was a case where a guy worked on a ship. He was a little bit effeminate in how he behaved, and this is like deadliest catch type ship, right? So people made fun of him and harassed him, and he sued under sexual harassment, and he won, basically claiming that, look, they were making comments about me stereotypical of or counter stereotypical of my gender and my role, and so that led to a claim for sexual harassment that was successful. So again, it doesn't necessarily have to be people their Harvey Weinstein model of sexual harassment. It's a lot broader than that.
And under the law, it typically falls into two different categories. The Harvey Weinstein is a great example because that's, as you can see here, the first category is called quid pro quo, and that simply means this for that. And that is your Harvey Weinstein. So that's the example where you have someone in a position of power who is giving some type of or offering some type of benefit. For example, to an actress, I'll give you a role in this new movie that I'm making if you sleep with me. It can also be to spare that person some type of detriment in their employment. So, for example, you can have a boss who says to their employee, we just announced these company-wide layoffs, but I promise that your position will be spared if you sleep with me. But the idea is that there's a direct sort of give and take or offering or exchange between the solicitation of a sexual relationship and something that the other person can offer in terms of the victim's employment.
And just remember, let me jump in one sec, Catherine. Also, understand it doesn't have to be explicit. It can be inferred. So there's been many cases where, there was a serial dater, we'll call it, who is a superior employee, and all of the women then get promoted, and then one woman doesn't get promoted and said, well, he came on to me, I didn't get promoted, but I wonder why, because I didn't sleep with him, everybody else did, and look what happened. So you don't necessarily have that explicit evidence. It can be inferential. The other thing to remember with quid pro quo cases, I always have trouble saying that fast, is that where a lot of the risk can happen is totally an absence of a quid pro quo. And what I mean by that is anytime you have a subordinate employee dating a supervisor, okay, there's different types of claims that can come in. One claim could be from another subordinate, because this is also a sexual harassment claim. Another subordinate says, well, I wonder why she's getting promoted and I'm not. I guess that's because it's his girlfriend. I have a sexual harassment claim. That can happen, okay? There's also a scenario where, relationship ends and now somebody claims it even though it did or didn't happen. Anytime you have superiors and subordinates in some type of romantic relationship, you have a very, very ripe claim for sexual harassment. I like to think of sexual harassment claims, for those of you who know me pretty well, I like sports analogies. And the way I like to think about these claims is people say, well, you have to be so careful nowadays. And, yeah, sure, there's some truth to that. But you don't have to be paranoid. What you have to do is you have to think of life sometimes as a baseball diamond, and you've got a warning track. And when you're on that warning track, then you got to be really careful. Anytime you have any type of employees dating each other, you're on a warning track. Just know that, because it doesn't matter whether it actually happens. It matters whether a case can be made. Go ahead, Catherine. Okay, we may have lost Catherine temporarily, so I'll just pick up here. So, there's a lot of times that you have sexual harassment claims where the individual is just making a joke. You think the whole, we were just kidding around, okay? And what those cases usually turn on are scenarios where you have an individual that is in the workplace and they may be joining a workplace where this is common behavior and nobody objects. You've got women doing it, you've got men doing it. There's sexually suggestive comments both ways. And then this one person comes in and they're not familiar with that sort of banter. And then they come in and all of a sudden they hear this and they feel offended. And that's a real scenario that happens very, very frequently in how these cases get started, because it's just, no one says, well, hey, she never complained about it. Well, yeah, but that's the risk you have if you enable that environment, even if everybody there truly consents to it. You've got to worry about what I call the person who's silently suffering. So if you could go to the next slide, Catherine, assuming you're still on.
Yeah, sorry, I lost audio for a second, but I'm back. So we have some specific examples of what that entails. A lot of times what we hear when giving these presentations is so much of this is common sense, but clearly it's not common sense for everyone. So we have some of the obvious things here that, yes, we would agree most people would know, but some of them aren't necessarily as obvious. And as Ari just touched on, a lot of them depend on the various sensitivities that different employees are going to have. You see assault here. A classic case of assault is rape or something egregious like grabbing or groping. But it can also include things like arm touching. Someone working at a computer and their supervisor or their colleague coming up behind them and putting their hand over the mouth. Blocking someone's entrance through a hallway. Every time the victim tries to get up to go to somewhere else in the office, they have a supervisor or a colleague who's making it so either they can't get past or they have to brush up against the other person to do so. All of that would be encompassed. Jokes, as Ari just talked about, stories, they can oftentimes be, a lot of times we see in complaints, they'll start off as harassers' stories about their own sex life or their sex life with their spouse. Anything that has a sexual overtone is going to be encompassed in these categories. Music is another one. I find a lot of times that people just have varying opinions about. You can have someone who listens to a song with really graphic lyrics, or perhaps suggestive lyrics that they really don't think anything of, and to someone else it can be incredibly offensive. And then this final category, there are so many different ways that we all use to communicate with one another now, that certainly everyone needs to be cognizant of all of them, whether they're through work email or, work messaging or private text messaging, social media messaging. All of it can potentially contribute to a sexually harassing environment.
Yeah, and obviously the last one you mentioned there, the emails, sending around, people send stuff around, right? And it shocks me to this day, the stuff that gets sent via email, that you look at in these cases, you're like, why did you ever think of sending some picture like that, right? That has some joke, and they send it office wide, and it's like, it's written evidence. So I don't know why people still do it, but it happens. I know you've seen it, Catherine. Text messages, sure. It's amazing those things still happen. We had, who was the guy, Anthony Weiner, a couple of years ago, the congressman. This stuff is amazing. People do it, though. All the time, people do it.
Right. And to Ari's point, just because you think something is private or you think you're sharing it with just one other coworker, certainly you have no assurance of that. Here we've got some more industry-specific examples that we see come up more often in the mortgage industry. Whenever you have an open layout, there's always sort of added potential exposure. One, for example, in a call center. One, because you have an atmosphere where everyone can kind of hear and see what everyone else is doing. So again, if there's a conversation going on between two employees that neither find offensive, that's one thing, but in a situation like that, you don't know who's going to overhear and who may find it offensive. Similarly, it sort of increases the severity if you have a situation where you have a supervisor who is making sexual advances or sexual comments to another employee. There's sort of one level of embarrassment if that's behind closed doors. If now everyone else in the workplace can hear it, that certainly can add to that, the victim's, embarrassment by the situation. Always in a fast-paced environment, things tend to get more casual, so people can be a little bit more lax about what they're saying. And also,
and I would also say that in a sales environment, sales environments too tend to carry on, just because of the personalities, a lot of banter sometimes, or comments about sales activities. Also, don't forget, though, in this, that it's not just employees, it is customers. Customers and vendors can sexually harass as well. And as an employer, you are responsible for that if you permit it to happen. So don't forget that. Sorry, Catherine, go ahead.
No, that's a great point. It's anyone that an employee may come into contact with or have interaction throughout their employment.
Yeah, and by the way, this includes, I know you guys are going to think I'm crazy, but these are real cases that we're talking about where, the woman has to go by the construction site to get to the office, and she's subjected to cat calls, on the way in every morning and every night when she leaves, and there's no other way but to go past the construction site. She says something to HR and says, because they do anything. Can HR respond and say, well, we can't control that. That's the workers. Wrong answer. You would have to, you may not be able to, but you're going to have to take some action. You have an affirmative obligation in these cases, so don't forget that.
So in response to the proliferation of sexual harassment claims and the attention that it's received in the media, and the entire Me Too movement, a lot of states have created additional legislation that either bolsters the federal legislation and the standards that we just talked about, or supplements it, fills in gaps that it wouldn't otherwise cover. So these are just some examples of states that have enacted in 2018 additional legislation that touches sexual harassment. New York State and New York City, we're actually going to get into a little bit more specifically. They are some of the most aggressive states and cities in the country right now in terms of how they're trying to eradicate sexual harassment claims. They've expanded the scope of coverage, meaning that it's no longer applicable just to employees, but also to independent contractors, unpaid interns. Essentially, they want it to be that anyone who is in an employment atmosphere or giving of their services to an employer could be covered by these laws. Illinois has kind of a unique one. There is now sexual harassment training required for any professions that are licensed by the state or that the state requires to get continuing education. So there's now a mandate they receive an hour of sexual harassment training. California has a similar training requirement. And this, as you'll see in the rest of these examples, a ban on non-disclosure agreements that include sexual harassment claims. So oftentimes, certainly customers. Go ahead.
Sorry, go ahead. I want to say something. Okay. Well, one thing I was going to say, and this is a little bit along these lines, but I wanted to make something out only because I had lunch with somebody yesterday. I had lunch with a client, and this particular company is has received a sexual harassment complaint, and their other lawyer that they'd been working with probably up until yesterday said, "Don't worry about it. We have an arbitration clause in our employment agreement, so you don't have to worry about it." Right? And the problem, you guys got to remember this, and a lot of you probably have these clauses, is that you can never take away the right of the state or the federal government to investigate and enforce sexual harassment laws, no matter what agreement you have. You could have an agreement that says it's absolutely not enforceable. Okay? So anytime you have one of these agreements, you think, oh, well, I don't really have to worry. They can only arbitrate with me. Not true. If they go to the EEOC or their state equivalent, which, they all have different names, but Human Rights Commission of a state, Employee, Rights Commission, whatever but they're called different things in different states. No matter what they've signed, that state can go in, can enforce, and can actually award damages to the person because you can't release that right from a state agency to enforce these laws. So this individual that I spoke to and had lunch with yesterday was pretty shocked and couldn't believe it, and then found out I was right. But I mean, you got to remember in your agreements, contractual protections in this area pretty much don't work at all, except a release that, where there's bona fide consideration. So just remember that. Sorry, Catherine, no, it's slightly off topic.
No. I mean, that kind of goes into, the same considerations for arbitration clauses. So we can see that California, Maryland, and Vermont have all implemented similar types of legislation. These, like I said, these are brand new. These were all enacted in 2018. So at least as to the arbitration clauses and a prohibition on including sexual harassment claims in mandatory arbitration, there's a lot of speculation as to whether or not those state laws are actually going to be upheld. Considering the very strong preference in the Federal Arbitration Act for allowing private agreements between parties, and also the recent Supreme Court decision in Epic Systems, there's a good chance that these, once challenged, may not be enforceable, but for now, they are.
And I just want to point out that's a little bit distinguishable from what I was saying, so none of the audience get confused. That's about the individual themselves bringing a claim versus arbitration. But when an individual goes to a government agency that enforces this laws, for example, the Equal Employment Opportunity Commission, EEOC, no matter arbitration agreement, you could have whatever agreement you want to call it. If you say, EEOC, you can't investigate me, they will look at you and heartily laugh and then proceed to do the investigation, right? Because there's just no way you don't have the right to get rid of an agency via an agreement with an employee. They still get to come in and do whatever they want to you, no matter what agreement you have. Even if you have a release, technically they could do it, but the release would mean that the individual was agreeing they wouldn't be able to receive an economic relief. But that's in a settlement and release agreement. But even there, like if they wanted to independently come in on their own for, let's say, another employee or something, I mean, you can't stop that. So it is a little bit distinguishable from what Catherine was saying. I just want to clarify for people. Go ahead. Sorry, Catherine.
Right. So if you had those different avenues, that one that Ari is describing has always been true. And if you used to have avenues to also to at least require, I should say, employees to have to agree to mandatory arbitration of their claims so that you at least knew you could stop private litigation. That right is now being restricted through these new state laws. So I just want to quickly go through. New York state law has both new strict policy and training requirements. Now, on one hand, if they were going to enact this legislation, it's nice that they have issued model policies. It makes it a little bit easier for employers to make sure they're compliant. Those are all on their website. However, some of the requirements they've put in them are fairly robust, really sort of cross the line in the amount of information that you're required to now provide to employees. One example of that is making sure employees know exactly how they can file a claim. However, because they're mandatory, our advice is certainly to follow them and to use the resources that the state of New York has put out. We talked about the requirement, or the prohibition, I should say, on having non-disclosure agreements that cover sexual harassment claims. There's a carve-out in New York state law for that. And the carve-out is that if the claimant, if the individual who is bringing the sexual harassment claim prefers that the settlement agreement be confidential, then it's permitted to be included. But you have to allow 21 days for that person to review the agreement, and even after they sign it, they need a 7-day revocation period. And again, there's also a prohibition on the mandatory arbitration of sexual harassment claims. Obviously, everything that applies in New York state law is going to apply to New York City employees. But the New York City law has gone just a little bit farther. It's expanded the statute of limitations from 1 year to 3 years. This may seem significant, but they were always pretty lenient in allowing, through what's called the continuation doctrine, by allowing acts that were all part of sort of the same series of harassment to come into a complaint, even if technically it was past the year period. But that it just shows they'll probably be even more lenient in that way in allowing, prior bad acts into claims. And also the standard under New York City law specifically is that rather than having to show, like we explained with the federal law, rather than having to show all the elements were met in terms of how severe and pervasive the sexual harassment was, the claimant in a charge under New York City law just has to show that they were treated less well than others. So it's not a incredibly high bar to meet. Again, New York City has model policies that they've issued on their website. They have a training requirement as well. Their training requirement, it should be noted, the law applies to employers of all sizes, but the training requirement only applies to employers with 15 employers or more. And that's not effective until April of next year. And if you have employees that are in New York City, you want to make sure that you keep records that they've attended all those training sessions. You can do it electronically, that's fine. Just make sure you have documentation of it. And finally, there's a notice requirement, and there is a very specific fact sheet that New York City has created that's on their website that you have to post in both English and Spanish. So now that we've walked you through some of the new legislation and some of the new compliance areas to be cognizant of, I want to talk a little bit about how the company becomes liable for the actions of its employees. So if you have a supervisor, someone who is in any type of managerial role, who is exhibiting or subjecting an employee to sexual harassment, there is always going to be liability on the part of the company if it results in a tangible employment action. So what that means is if it somehow causes the victim employee to suffer something that is detrimental to their employment, like termination or demotion, a pay cut, an unfavorable transfer, unfavorable hours, then there's no question the employer is going to be found liable for that supervisor's actions. Now, if you have a situation where a supervisor creates a hostile work environment for an employee, but it doesn't result in a tangible employment action, so nothing actually happens in terms of the fundamental conditions of that employee's position, they continue on in the same position, the same duties, earning the same compensation, then there is a potential affirmative defense for the employer. And this is so important because this is the type of thing, if you're in litigation and you successfully present this affirmative defense, it can end the entire litigation there.
Well, let me also jump in. Before you're in litigation, if this is when you should run, not walk, this is when you run to a lawyer and your lawyer, you give him a big Christmas present, okay? Because and this is a situation I had a couple years ago where we had a supervisor, there was clearly sexual harassment once we learned of it, but the employee quit, which would be considered a constructive discharge because there was pretty good evidence of severe harassment in this case. Well, we found out after the person quit. We realized, they came to and said, what do we do? And we said, well, you're going to get sued, and you're going to get sued for a lot of money, and you're going to lose. So what we immediately did is we suspended, after this person had already quit, okay? We suspended the other employee immediately. Who was a manager. We reinstated the other employee, said, come back, we'll do whatever, we'll get you back here, and you're not going to have to work with this person. Oh, and the 3 days that have gone on that you haven't worked for us, we're going to actually pay you all of that money, restore all your vacation. This never happened as far as we're concerned. And the person came back. Okay, actually, the person didn't come back in that scenario. But because they had been offered full reinstatement, there was actually no tangible harm that had befallen them. They would have continued work, and it became a viable defense later in the case. Only reason they had that defense is they'd come to us, and we'd put that in place to present and preserve that defense, which they later utilized successfully in the case.
And so here are the elements of the defense that we're talking about. You want to show it's two-pronged, and it looks at it both from the way that the employer protected the employee and the employee protected themselves, right? So the employer has to have, the legal term is exercise reasonable care. And typically what that looks like is making sure you have sound, clear, written policies, you have a reporting structure in place, that the employees are aware of your policies and your reporting structure, usually through training and the distribution of those policies, and that if someone complains, the employer actually takes some type of an action.
And note of those policies that you want to make sure that you have alternative reporting channels. So, if the CEO is the one who's accused, there was some other way to report other than, if you follow what I'm saying, go to the CEO. So if you need to have alternative reporting strategies, so that if it says, for example, better warnings, go to your manager, and report it. Well, if your manager is the one who's doing it, you're not going to report it to your manager. So maybe you do it to the head of HR, some other alternative reporting structure.
So provided those are in place, the employer has met its obligation to be able to claim this defense, and then the employee, it has to be shown that the employee unreasonably failed to take advantage of them. So typically what that looks like is that the employee just clearly knows how to complain, who to complain to. They're all reasonable structures for doing that, and they don't take advantage of anything, and they just essentially say nothing. So this slide represents instances when there's going to automatically be imputed liability onto the company. So again, these are the cases that we've seen so much in the media. If you have someone who is the founder of a company, the CEO of the company, someone is so high ranking within the company, the law views them essentially as a proxy for the company. So it doesn't matter whether or not the employee or the alleged victim suffered a demotion or suffered some type of detrimental employment action. Irrespective of what happened with their employment, the employer is going to be found liable just because of how highly ranked the alleged harasser is. And there also, I think it's a common misconception that you can't have two employees who, say, are on the same organizational line or who have the same type of position, where one doesn't really have any supervisory or managerial authority over the other one. There's still the possibility that the employer can be held liable for any type of harassment that occurs between those two. And they can be held liable in a situation where you have any type of management level employee who has actual or constructive knowledge. Two parts of that are important. It doesn't need to be, say you have two coworkers who share the same position. Let's say you have two loan officers. It doesn't need to be their direct supervisor who has knowledge of the harassing behavior. It just needs to be anyone who is management level. And the other piece of that is actual or constructive. So there's no room here for a manager to turn a blind eye. If the manager hears rumors, if the manager oversees something or hears something, but it's not his or her direct reports, that can still impute liability to the company. So because this is true, it's so important to make sure management understands that it's not just an instance where someone comes to them directly and reports sexual harassment when they have to act. It's also if they're at all aware of it or they see it or they hear about it. So we're going to go through, in light of all this, in light of the ways that liability can come back to the employer, we're going to go through some best practices generally, and then sort of specifically what you want to do in terms of policies and training. So irrespective of how much training you do or what type of policies you implement, if you don't really ascribe to it in terms of an entire organization and sort of build it into your culture, it's probably not going to make much of a difference. Obviously, that's harder to do, but you want to start from the top down. So to make sure that your C-suite is trained, that your high-level managers are trained, that they understand they need to be exhibiting behavior and indicating that the zero tolerance policy on sexual harassment is taken seriously by the company, and also that the company is not going to make any exceptions for anyone. A good example of this was when we saw NBC acted quickly when allegations surfaced about Matt Lauer. He was the face of their Today Show, and they still terminated him, and they acted quickly. That really shows, that's the type of message that's sent to the rest of the workforce that shows the company is taking it seriously. Similarly, you want to have the same message throughout the organization. So just because someone is generally thought of as innocuous, but maybe they make inappropriate comments, there's no room anymore for kind of taking an attitude of that's just the way the person is. They've been at the company for 30 years. Everyone's sort of accepted it. That's the type of stuff that can come back and ultimately, be fodder for a potential claim. And again, like I talked about when you're talking about instances of coworker harassment, it's not, the company culture should not only be holding people who are actually engaging in harassing behavior accountable, but also those who are turning a blind eye. One, because it facilitates the atmosphere, but two, it really exposes the company.
And just remember, look, this is one of the biggest things that, anybody in a sales culture has, because if you have that one rock star salesperson who's doing these things, there's no exclusion in these rules for high producers, right? You just have to realize that you have to deal with those issues one way or the other, and because they can come back to bite you. And if I will tell you this, like from being on both sides of these issues, if you're the worst argument you want to have if you ever go on a trial, say, yeah, they knew about this, but he made too much money. Guess how we're going to teach them a lesson, right? That's when the jury, when you see those numbers that Catherine showed you earlier, that's how plaintiffs get those, right? Where somebody made a very intentional decision to overlook something because of the bottom line. And then the only way to teach them is hit their bottom line so they never forget. Juries will do it.
Right. And this slide goes right into Ari's point. It may be painful in other ways, but, the highest level, the highest producing employee has to be treated the same way as someone who is, a lower level rank and file. That's not to say termination is the only answer. We'll get into it a little bit more. You obviously have other creative solutions at your disposal. And again, CEO, president, founder, because of the way they impute liability to the company, they're also high risk. And then finally, if you have anyone who's in charge of HR or compliance and they're your bad actor, it's going to sort of taint the rest of the workforce because people aren't going to feel that they can come forward and report or that their claims are going to be taken seriously. And then you have no idea what else is going to erupt and potentially go unnoticed or unaddressed.
One thing I also want to say before you go before you go to triggers, this is really important because I think what you have to know is that an ounce of prevention, okay, not only talking policies and procedures, but we're also talking about, this is one of these areas where I think if you have a good employment lawyer and they really have some experience, they can tell you how to handle these issues so easily. And I want to give you one quick example, which is a scenario where when I was learning employment law, then I was maybe a first-year associate. We had pretty big rainmaker, and not at my current law firm, another law firm. And this person had just come over. There was a big acquisition for the firm, and the guy almost immediately started harassing. It was clear. Everybody knew it. It was within 2 weeks. He was doing everything to the pretty paralegals that were there. Right? He was. Not overt, but just none of them would go in his office. They were all fully comfortable. Managing partner says, "Come here, you need to come with me," pointing to me, and I don't know what I'm doing. So we go walk in the room, and he proceeds to say, "Hey, and talk to his partner about how the Christmas party was coming up. And he was really worried and said, it's going to really be tough. Like, what are you going to, I'm just worried one of these women who've been like say something to your wife at the Christmas party. We would hate for that to happen, wouldn't we? Right?" And he looks to me and he goes, "Right? It would be terrible given what people are saying if anybody ever talked to his wife about that at the Christmas party, wouldn't they?" And, I'm just sitting there kind of staring. But the point is, that guy never talked to a paralegal again. Okay. And it was not he handled it right up front, very quickly. There was no big deal, right? And took care of the whole problem. The right type of advice at the right time can diffuse these things immediately. So the next time you see one of your high producers doing something, don't feel you shouldn't act. That's exactly when you should act. Because when you can when you could stop it on a dime right there with something real easy, that's when you act. When it continues, and it gathers steam and momentum, and that's when it's so much harder. So I know a lot of people feel like, oh, well, maybe it won't happen again. Let me overlook it. That's the worst possible thing you can do, because when, not if, when it comes to fruition, you're going to have a billion times the problem. This thing he handled one time. The guy was quiet as a church mouse from then on out. Never had a problem. So I just wanted to throw that in so you guys thought about it.
Sort of keeping in that same vein of triggers that'll lead you right into litigation. You find that I like this slide because these points are actually told to us by a plaintiff's attorney. So you have someone whose bread and butter is bringing these types of claims against companies, saying, like it or not, when people come into my office, these are the reasons that they commonly list that kind of pushed them over the edge, that made them angry enough to potentially sue. So in doing an investigation, sometimes you're going to find that the alleged victim's claims are credible, and sometimes you're going to find that they're not. But you have to be careful about how you relay that information. First of all, you always want to close up the loop with the complaining employee. But avoid saying things like, "We found you not to be credible, we found your concerns unfounded," unless, of course, you're dealing with an extreme situation where you know that this employee is fabricating the complaint for some nefarious reason or to get back at another employee. You want to try to stay neutral in your conclusions to them. Never delay in responding to concern. These are things that should jump up to the top of your priority list. Especially right now around the holidays where things are so crazy. You have both, they're crazy in business, but then you've also got a lot of holiday parties, events, things where these types of situations can come up and can cause someone to complain about someone's behavior. Don't let it go. Don't let it go into the new year. Make sure you're responding to it quickly. during an investigation, you always want to talk to everyone who the complainant has identified. I can't tell you how many times I've seen where the employer does an investigation, but really they've only talked to the person who's complaining and they never address the alleged harasser. That, of course, that should be step one.
And there's another important part here, is like when you're doing the investigation, one of the reasons you want to do it is you want to know what's out there, because if it does turn into a claim, don't you want to know all the potential evidence that's out there? You've got to think about these investigations are sort of like pre-litigation evaluations of your situation. So, if you don't do that, then you're deciding to not look at all the information. And if it's bad, it's really going to blow up in your face, because then you're subject to the question of, yes, but if you would have done a thorough investigation, you would have known this is true, correct? Now, how do you answer that question? Not in a deposition, it's pretty tough.
Right. So it's worth the time that it takes to be more in depth. Also, you want to make sure, certainly you can always, and I would recommend, whether it be your in-house counsel or your outside counsel, you can have someone sort of guiding you through the whole process, have counsel guiding you through the whole process, but don't actually have your attorney being the one you don't want someone to complain and the next thing they're faced with is the company attorney or outside counsel. That's not the type of, certainly that doesn't give the impression that the company is investigating it with the aim to resolve it. It looks more just like the company's on the defense. Also, same thing, while, exposure is always a concern, don't immediately assume because an employee has complained that there's no way that they can continue on in the organization. These types of complaints run the gamut. They can be serious. They can be something that the employee just can't get over. There can't be a resolution to, or they can be something just less serious. They can be, an employee just wants someone, some other coworker made a comment once or twice, and they just want to make sure it never happens again, and there are ways to resolve it. So don't go right to, there might be a time when it comes when you want to talk about separation and offering a severance agreement for release, but that should never, ever be your first or even second step. And of course, being lax about the confidentiality that surrounds a complaint or an investigation, that's going to lead an employee to feel like their situation's getting worse and potentially go call a plaintiff's attorney. So here's sort of a rundown of the best practices to avoid triggers. You want to have a clear written policy. You want to make sure everyone is aware of and gets the policy and actually reads the policy. You want to make sure that you have training for everyone. That should occur probably annually, and make sure that people are updated. You want to make sure you have an investigation protocol and that whoever is in charge of the investigation knows how they can remedy the situation and what type of solutions they can employ. Another one that we see a lot, it's not as if these types of complaints exist in a vacuum. So you might have an employee who is suffering from performance issues, which you need to deal with. That employee may have credible, or what you find not to be credible, complaints about sexual harassment at the same time. Those things should remain completely separate. Whether you think it's dubious that their complaints are credible because they're coming on the heels of this person receiving discipline doesn't really matter. You want to make sure that you're showing that you dealt with their performance issues separately. So if they need discipline, if they need a performance improvement plan, or they need a meeting to help with their performance issues, fine. But don't ever combine that with any type of meeting where you're doing, your initial interview of them, of their complaints, or the meeting where you're following up on the investigation. And finally, you want to make sure that you're always documenting everything. I always like to recommend, even if it's just in a quick email that you send yourself, that's always nice because you've got the date on there, but make sure that you're always taking contemporaneous notes. So here are some specifics for your employee training. we suggest doing trainings, and you can do them in person or you can have them as a webinar or as a click-through. Unless the state you're in has strict requirements as to how you have to actually do the training, it's sort of up to your discretion. But there is different training for different types of employees. So I would recommend doing them separately for your rank and file versus your management versus your C-suite employees. Just because some of those people are going to be in positions where they're receiving complaints and responding to complaints, they have different roles within the company. You know, some, like your higher level management is going to be part of the group that sets the culture for the company. So it's important to make sure the training is focused. And again, you want to make sure that people understand the conduct they're not supposed to be engaging in, what's prohibited, but then you also want to make sure that anyone who might be in a position to receive a complaint or learn about sexual harassment knows exactly what to do to handle it. Again, the C-suite should never be excluded from training. Obviously, it's probably going to look different for these individuals, but certainly they should still receive training. And, you know, we gave some examples of why it's so important at the beginning, because you can use any one of those angles to really impart the seriousness of these types of claims right now and the potential damage they can have on a company. So you want to make sure that you have a strong reporting procedure in place. I have some statistics for you here, specifically of the mortgage industry. A recent study showed that over 70% of women in the mortgage industry reported feeling like they've been subjected to some type of sexual harassment, but only 20% have said they actually reported it. You can only do so much to make sure that people feel comfortable, but you should take every effort that you can. These are some of the reasons that women, you know, are disinclined to report. I shouldn't say just women, you can be men as well, but that people are disinclined to report any type of harassment that they believe they've suffered. Retaliation is a huge one, and I'll go over in a second the type of anti-retaliation policy that you should have. But a lot of them, especially when you're in an industry like this one, where it can be tough, it can be fast-paced, people don't want to be accused of not having a sense of humor or not, you know, being properly cut out for the industry. They don't want to risk coming forward and then not being believed. You know, and it's the type of sexual harassment or the type of comments or advances that are making them embarrassed to begin with. They might have a hard time coming forward to whoever they're, you know, whether it be HR or a manager, and repeating the comments because they find them to be embarrassing to begin with. They're all, you know, valid. We understand where they all come from. So the best you can do is sort of be cognizant of them and to make people feel like the company really is encouraging reporting, and it's going to be taken seriously. Make sure, Ari mentioned it earlier, make sure that you have multiple avenues for reporting. Be really thoughtful when you're creating your policies around this. If you have say it's a family-owned business, try to make sure you have one avenue that someone outside the family, you know, make sure that if it's not HR, someone could go to their manager, can go to their supervisor. It shouldn't only be, say, the CEO that someone can report to. And you always want to stress the confidentiality. Anyone who comes forward should be aware that in order to do your job thoroughly, like we just talked about, the way that you should, you're going to have to interview people. You're going to have to tell them the allegations if you're going to ask them if they're true, but that the company will do its best to maintain the confidentiality of the employee who complained and to make sure that other people who have nothing to do with the complaint aren't made privy to it. The most important thing I can say about investigations, aside from making sure that you do them quickly, it's certainly up to you whether or not you're going to use outside counsel to conduct any interviews of witnesses. But just be aware, you should plan it in advance, especially if you have a larger scale investigation that you're about to partake on. Make sure that you are aware of the fact that if you have counsel interviewing witnesses, there may come a time when you want to keep those interviews privileged. You can't play both sides. So you can't both should there be litigation down the road. You can't both try to use the defense that you properly investigated a claim and use the investigatory file as part of your defense, but then say that part of it is privileged because you had an attorney conducting those interviews. So be really careful with this one. Another way you can get around that is just to make sure you have in-house or outside counsel advising on the investigation, but not actually conducting it, so you don't run into a privilege issue. Make sure that you don't just do this great lengthy investigation and have all these notes and have a whole investigatory file, only to then leave it in some red weld and never come to a conclusion. A lot of times what I hear is people are so concerned about actually coming to a conclusion that they sort of just say, well, we did the investigation and that's that. You don't have to be right. There's no way that the law requires you to come to you're never going to know for certain exactly what happened. You just have to make a reasonable conclusion. So if you talk to all the witnesses and ultimately find that the complaint isn't credible, it's okay as long as you have good evidence for that conclusion, but you do have to draw one. And of course, you want to circle back and make sure that the employee knows that you completed the investigation. You don't have to tell them exactly what you're doing in terms of remediation, but you want the employee who complained to know that it was handled. You can say, if you do find the complaints credible, you can tell the employee that you've taken it seriously, that you're addressing the concern, and that the person who was complained about is receiving some type of action from the company, and you can leave it at that. And then finally, you want to make sure you maintain some type of record of the discipline that you gave, because you want to be consistent. If you have similar factual scenarios in the future come up, you want to make sure the discipline that you administer is similar. And then finally, a really strong anti-sexual harassment policy doesn't work without a really strong anti-retaliation commitment. So employees have to know that the company strongly prohibits retaliation and that you will address it the same way that you would address any finding of sexual harassment. So if you find that you can have an employee who is completely unrelated to the original complaint, but happens to really like the alleged harasser, and now they're giving the cold shoulder to the complainant, or even worse, they're somehow detrimentally affecting the complainant's position. That person needs to be disciplined the same way as if that person was engaging in sexual harassment. And it's important that employees believe that to be true. Just to sort of drive that point home, in 2017, you can see there were over 12,000 sex-based harassment charges filed with the EOC, which is certainly a high number, but there were over 41,000 retaliation charges. So this is by far the most common type of claim, and oftentimes we see in litigation, this is the one that sticks. The court might find there was no sexual harassment, but that the employee was subsequently terminated or demoted in retaliation for complaining. So it's important that you take that piece of it just as seriously. And Ari had to jump off a little bit early, but here is both of our contact information. If you have any follow-up questions, feel free to contact either one of us. We're happy to answer questions, and we appreciate you attending today.